Brad Williams, Labor Compliance Group. The challenges the industry imposes on you and every player when doing prevailing wage projects sometimes is overkill. I'm going to try to keep this particular newsletter as short as possible, but here's a case. We have a civil wage penalty assessment, nearly $900,000. Here are the players. Office of Contract Compliance for the City of Los Angeles. The defendant, Belco Electrical. What's going on here? Well, in summary, let me tell you about the contract compliance for the City of Los Angeles. There are 4 legacy labor compliance programs still in the works. This is one of them. City of Los Angeles, Caltrans, Sacramento County, and I believe the school district of LA. It could be San Diego. What it is, it's a self-regulatory umbrella within DIR. As I said, legacy. So the City of Los Angeles has their own in-house compliance. Only after a complaint in the City of Los Angeles enforces their interpretation of DIR's rules and regulations will DIR come in and make the final decision on whether the City of Los Angeles and their actions are accurate. Over the years, I've heard how heavy-handed the City of Los Angeles is in terms of prevailing wages. Here, as I stated, they're assessing Belco Electric nearly $900,000 in civil wage penalties. Who's right? Who's wrong? As I said, you're doing any type of construction-related work in California, specifically in the way of public works, it is cumbersome. I take my hat off to anyone who goes down this route, but maybe you will keep in mind with the challenge you may face, and you would never have thought of it. Here's a case, and again, straight up, everyone lies. Everyone lies. Contract compliance, they lie. Belco, they lie. The workers, they lie. So who has to settle all of this? Who has to go through all the weeds in order to find the good from the bad? Well, in this particular case, looks like DIR had to siphon all the chaff and try to work through this thing. As I said, this is a 47-page decision. I've never seen anything that long. I've read 33, 35. But what's going on here? Well, there are a lot of inconsistencies. There are a lot of things here I've never seen before, and there's some overkill. So let's get to the meat and potatoes. Belco is a subcontractor working on the electrical component or electrical part of this particular project. It's a San Fernando road bike path, phase 3 in LA County. The notice indicated that there were $469,000 in unpaid prevailing wages and $433,000 in statutory penalties. This is what contract compliance came up with. Contract compliance for the City of Los Angeles. Again, this is the legacy component of DIR. At a hearing, and you're going to see way too many players here. You're going to have the individuals on behalf of the city, and then you're going to have the individuals on behalf of Belco. You're going to have the attorneys. Then you're going to have the interpretation by DIR. There are tons and tons and tons of footnotes here. I'm not going to go through them all. I'm going to leave this up to you. This document is available on DIR's website. That's where I get all this stuff. It's public information. Hence, that's why I'm presenting this. This thing was recent. This is the most recent decision that I've read. And it was released just right before Thanksgiving of 2024. Here it is, the beginning of the new year of 2025. The matter of this decision was made on April 26, 2024. So this is new. This is relatively new, but we have to go back to some timelines here. And I always bring this to people's attention. When did this thing start? When did the project start? Well, we'll get into that here in a second. Here are all the players. You're going to have a lot of names, and I'm not going to go down the names. There's too many. I'm just going to point out the arguments. Here is what is at stake. Whether Belco underpaid prevailing wages to workers on the project, whether Belco failed to keep accurate payroll records, whether the workers on the project work additional straight time hours not accounted for in their payroll records, whether the workers on the project are entitled to prevailing wages for travel time, and if so, at what rate. You know, you've seen my other videos on DIR's new opinion, and there was a new ruling that I was not aware of, and it's brought to my attention here. I'm not a lawyer. Just straight up, this is absolutely no legal advice whatsoever. I am the messenger here. I'm passing on maybe some helpful tips. Maybe something here you're going to go, well, Williams, you say this over and over. Well, yeah, I like to beat a dead horse to the point where if you're doing public works, my goodness, follow the rules. Follow the rules. Whether Belco is liable for liquidated damage, and if so, to whom? Whether OCC and OCC, Office of Contract Compliance, they're going to use this acronym repeatedly. So I'm going to use it. Whether OCC used the proper prevailing wage rates for each applicable classification based on the bid advertisement date for the project. And this is always a point of argument here, because here DIR saying the wage applicable at the bid advertisement date. But then if you look at the prevailing wage determinations, they always say you have to pay the most current rate. And I'm going to step a little bit forward here as we discuss some of the numbers further on. DIR still is not clear as to what the rate is at the time. Is it current? Is it the bid advertisement rate? It's unclear. So I'm not going to make any comments on that. It's just a point of argument that needs clarification. Whether OCC calculated correctly the underpayment of prevailing wages attributed to each worker in the notice. Whether OCC is permitted to receive fringe benefits found due and owing to unions. Whether OCC abused its discretion in assessing penalties. Whether OCC permitted penalties assessed under Labor Code Section 1775 and 1813. All right. So straight up, for the reasons set forth below, the DIR finds that OCC did not carry its initial burden of presenting evidence that provided prima facie support for the majority of the notice. Yeeks! All right, so you can turn this off right now and go, all right, we get to the point that once again, we are being strong-armed by these agencies, and subsequently, we have to go to battle and we have to spend our money based on their mistakes. I play the devil's advocate here because look at the errors. This is just crazy. I'm going to get into some stuff here that you're just going to go, I can't believe it. Here we are. It's a project involved a bike path for 4 to 5 miles near a railroad track along San Fernando Road. Fine. Seems like a pretty basic deal. This Belco company, they're putting in traffic signals and street lights on the project. Well, it seems like pretty standard practice. Project timeline, April 27, 2020 through November 3rd, 2023. Seems like a long period of time for a 4 to 5 mile project, but it is what it is. Here it is. The investigation. OCC initiated an investigation of Belco in response to workers' complaint that Belco, along with other traffic signal and street light contractors, paid workers for 8 hours per day, regardless of whether the workers performed overtime work. All right, fine. After OCC learned of the worker complaints, OCC held a meeting on January 19, 2022, with all 35 of the city's traffic signal and street lighting contractors, including Belco, and advised that it would not assess any penalties if the contractors self-reported violations and paid restitution to workers. None of the contractors responded. Why would OCC go to that length? You got this guy here now. Jensen has been the labor compliance officer for the last 8 or 10 years. Really? Either he's been there for 8 years or he's been there for 10 years. But why is there a variation of 8 or 10 years? And he oversees staff in monitoring and enforcing the payment of prevailing wages on the city public works construction projects. This is the guy who is overlooking this whole thing. And I don't know, they say he's been there 8 or 10 years. It should be either he's been there 8 years or he's been there 10 years. He's been there a while. You'd think he knows what he's doing. During its investigation into Belco, OCC contacted and interviewed approximately 90 to 100 current and former Belco workers. What? Are you kidding me? Why? Specifically, Pertaining to this project, OCC interviewed 36 Belco workers. Jensen interviewed 32 workers, and other OCC staff interviewed the other 4 workers. 36, are you kidding me? Does this guy have nothing better to do? As part of the investigation, Jensen and other OCC staff completed employee interview forms for the workers they interviewed. All right, so they go through and they interview 36 people here. Kind of just going a little overboard, all right? And again, you're looking at 36 people. Well, get this. Jensen, who oversees this thing, interviewed about 75 Belco workers. Really? One could imply that Jensen could have been a little bit retaliatory towards his company. I can't imagine how much wasted time and energy this is for employees not even related to the project. OCC witness firm spoke with Jensen regarding their experience on the project. All right, this guy just went way overboard from first impressions. As I move on, OCC reviewed Belco certified payroll records to determine that the hours reported were not correct based on the information provided by the interviewed workers. Once again, I always state that the state of California is always in favor of the workers, that you as the GC and the sub are pretty much standing over the fire, and that's just wrong. Because, why? Because workers lie. OCC requested documents from Belco, such as time cards or time sheets that would show a worker's start and break times, and truck records or vehicle logs that would show when vehicles were turned on and off and for how long the vehicles were driven. That's new to me. I've never seen a rule that states that it's a requirement, but my goodness, is that where we are? Well, I offer courses. I provide training. I'll provide a link in a minute as to where you can get that. The courses I used to charge $750 for. It's now all online for $250 or $260. I address all of this. So for goodness sakes, and this is never ending. I mean, there are hundreds and hundreds of civil wage penalties that are noted in DIR's web link. A simple $250 investment. I address all of this stuff. But when you walk into a project, you know what's going on. There's no hidden agenda there. But here, Belco did not have such records. Well, why would they? The time cards and the start and end times, yeah, they need that. The vehicle logs, well, you now know to what extent the DIR may go to. Relying on the information obtained from the worker interviews. Here we go again. Relying on strictly what the workers are saying, OCC prepared an audit that found Belco underreported hours and underpaid workers on the project. Wow. Is that any surprise? I have to laugh, okay? Because how many times have I presented this, either in just the written documentation or maybe in a subtext, that I say that workers lie? Well, here we go. Are they lying? Well, stay tuned. Now, here's the case where this Jensen guy says, relying on the information obtained from the worker interviews. He's making this crazy assumption. According to Jensen, in the absence of accurate payroll records maintained by the contractor, or in this case, a subcontractor, it was appropriate for OCC staff to estimate the hours Belco workers worked on the project in accordance with the decision of the United States Department of Worker, Labor, Wage, et cetera, et cetera. All right, so they went along and just said, well, we're going to follow some federal guidelines. I don't see anywhere where it says Jensen Esquire or Jensen Attorney. So I guess he's going out, taking a big leap here. Specifically, and this is critical here. Specifically, Jensen directed OCC staff to assess 3 hours of unpaid overtime per day per worker for every 8-hour day recorded on the CPRs. Wow, that's pretty bold. That's just going out there going, well, I'm God. So I'm going to make up the rules as I see fit. Unbelievable. The audit was prepared under the assumption, there we go again, there's that damn word assumption, that every worker on the project reported to work at the Chino yard, as Jensen testified that OCC was not aware of the use of other Belco yards at the time. Again, there's some technical issues here. Here's the audit. On October 12, 2022, OCC provided its summary of assessment, wage restitution, and penalty log dated October 6, 2022 to Belco. I think Belco was a little bit stunned. So anyway, here's the process. They're going through this deal here where OCC, because they are a legacy labor compliance program, they can do this. We're going to go into some other technicalities here. We're looking at wages, crafts, who's who, who's what. This OCC said there were 9 different crafts on the trade, on the project, from journeyman to apprentice, so on and so forth. That's not really the issue here. We're slicing this up into tiny slices here, and we don't need to do that. So I'm going to go on, and it said, the audit was not calculated based on the prevailing wage rates in effect as of the bid advertisement date on the project, April 20, 2019. Now keep in mind, this is a union shop. Instead, the audit was calculated based on the actual wage rate listed on the CPRs, which were higher than the applicable prevailing wage rates. OCC is using this prevailing wage rate. DIR is mentioning the advertised bid date, and no one clarifies what rate to use. According to Jansen, if the actual wage rate was higher than the applicable prevailing wage rate, then OCC was entitled to enforce the actual wage rate for purposes of calculating unpaid overtime. And now they're stating they need to use the actual wage rate. As a union contractor, Belco paid the union rate on this project. But here we have this number 14, this footnote. Jensen explained that Tom Fredericks, an attorney for the Labor Commissioner's Office, told him in 2012 or 2014, I don't know, maybe this date, maybe that date, you get the point. Told him in 2012 or 2014 that OCC could enforce time and a half of the rate actually paid to workers. See Office of the Labor Commissioner Public Works Manual, October 2023. Now, I've gone over this manual, and this is part of my training, and I've never read anything about this particular argument here. Back there, as a union contractor, Belco paid the union rate on the project, which was higher than the applicable prevailing wage rate. As I state, you cannot pay anything less than the applicable prevailing wage rate. You can always pay higher. The audit included unpaid training fund contributions. Jensen believed the audit also included penalties under Labor Code 1775, calculated at $200 a day. Again, this is something that DIR has a starting number and then a scale. So it starts at $40 a day and can go up to $300 a day. So Jensen believed, again, this is Mr. Jensen with 10 years of experience, or maybe 8 years. Jensen believed the $200 per day penalty rate was appropriate because he had heard from the International Brotherhood of Electric Workers, again, they're God times 2, business agents, that the practice of not paying overtime hours had been going on since 1965. And because multiple workers he interviewed for this project said that they were afraid of retaliation. You know, I always say, you always hear on the street, and this is a perfect example of hearing on the street. So this guy just picked a number out of thin air. So he said $200 a day. The audit also included penalties under Labor Code Section 1830, calculated at $25 per day set. And that means if you failed to pay overtime, you're going to get hit with a $25 per day per employee. The notice on June 26th, OCC issued the notice of withholding of contract payments to Belco. Again, we got a couple different dates here, not really that important. But again, we have a footnote here. It says the copies of the request for approval of forfeiture by the parties references a different project. If you're working on a project, I always say cross the T, dot the I's. Cross the T's, dot the I's. Cross the T's, dot the I's. You kind of get the point there. Here, they're referencing a different project altogether. In the end, it says the parties' failure to submit OCC's request for approval of forfeiture for this matter deprived the hearing officer of the ability to review OCC's required summary of the nature of Belco's violations and the basis upon which OCC made the determination of underpayment of wages. Again, OCC is just full of error. You kind of get the drift here. You're working with awarding agents. You're working with DIR. You're working with, in this case, a legacy labor compliance group that is subject to interpretations of their own, leaving you not only having to get your project done, but in the back of your mind going, these guys can hit me with a penalty based on perhaps what a worker says. Now we go into the subsequent investigation. OCC is going to argue one thing. They're going to say daily activity job reports. The defending group, Belco, is going to go, well, no. We have our four people or four persons, our foreman on the job, and he's keeping track of all this stuff. Well, guess what? Foremen also lie. Got a bunch of liars in this group, and some people that, well, actually keep records. Now, you can go through this. I'm not going to weed through all of this stuff. This is a he said, she said, and it goes on and on and on. And again, you're going to have Jensen. Wow. This guy either lacks the ability to delegate, doesn't trust his workers, or is so much of a micromanager that he is so retaliatory that perhaps Mr. Jensen may want to find himself retiring or perhaps find another job, because I think I'm kind of leading up to the end of the story before we get there. The witness, and here we go again. We got this Ochoa guy, we got Jensen, we've got a whole number of people, and they go back and forth. Back and forth. Ochoa testified. He's one of the foremen on the jobs, and he's saying, look, we did everything by the rule. Then we have this De Leon guy. De Leon kept records on his cell phone, so it says. He goes on and he says, on behalf of this company, Belco didn't pay me what I was entitled to. And this went on and on and on for 23 days. So all the records were audited, so on and so forth. And about 40% of what this De Leon guy says is somewhat accurate, and then 60% is a little bit exaggerated. Then you're going to have this Ramblaz guy, and then this Tiscarino and Balderas and so on and so forth. And it just goes back and forth, back and forth. In the end, there's 9 plaintiffs here, for lack of any other word. Of the 100 people that were interviewed, 9 are actually testifying. And then you're going to have 4 or 5 foremen also stating otherwise. And then you're going to have the labor compliance officer for Belco testifying. And they go back and forth, back and forth, back and forth. So you have this Jensen guy working for the city. You're going to have Belco and their people. Then you're going to have the employees. And they're going to have the number of days they work, perhaps how long they've worked for Belco, whether they're a good guy, whether they're a bad guy, what they did. Did they work overtime? Well, about 60% of the people interviewed, of the 9, 60% said, no, we never worked overtime. Then there's the 4 that said, oh my God, we were working 17 hours a day and we were only paid for 8 and we weren't getting our breaks and so on and so forth. He said, she said, and it's repeated over and over and over. All right, the 4 people or the 4 persons for this project, and you can see there's Ochoa, Julio, Ferguson, Escarino, Pina, Caldera, Cunicio. Okay, and they went on and on and on, and they're going to state, yeah, everything's accurate or mostly accurate. Then you're going to have the 9 are saying the opposite. And they're going to go back and forth. And the workers are saying, sometimes they would show up at 6 o'clock in the morning and then leave at 5 at night and so on. And the 4-person witness testimony regarding the accuracy of the contractor daily report conflicted. Ochoa testified for Belco, testified that the hours worked he recorded were accurate. Pina says that they were accurate. And then this other guy says, well, maybe they were mostly accurate. Again, you're looking at guys that this isn't their job. Their job is to make sure the project's completed. Well, now perhaps they will review their policies and change how they do their reporting. Subsequently, there's a point to all this. If you haven't picked it up by now, well, I'll remind you here shortly. We're going to see this pre-project site activities. And the question here is, at what point do you start paying prevailing wages? When a worker shows up, if it's related to the job, then the rules state prevailing wages must be paid. And here the argument is, well, there was a safety meeting before we started work. Well, if you have control of the worker, then you got to pay prevailing wages, period. The argument is, well, I didn't go, or I wasn't required to go, or I did go, or they didn't pay me if I showed up, and on and on and on and on. And so you have this piss and match between he said, she said, and this is normal. This is a policy issue. Small companies to big, you have to track everything in today's era. Why? because you're going to get situations like this, and it's going to cost you a bloody fortune. I can't imagine, and I'm going to applaud the attorneys on behalf of Belco, because they just went way overboard. They pointed out a few things that are new to me. And I read a lot of this stuff and it is boring, but there were a few legal issues here that are really kind of unique. And it's because this was a labor compliance program and not a DIR related issue. A lot of what OCC did was inaccurate. This is a fault on OCC, and I'll bring that up here in a second. PINA's informal training consists of writing down the workers that were present each day along with their classification. All right, again, this right here, informal. You can do in public works, you cannot do anything informal. As you are probably picking up here, how detailed this is. 47 pages. DIR turned over a lot of rocks in order to audit this thing. And that's crazy. I can't imagine how much money's wasted. This Jensen guy interviewing 100 people, my goodness, what a waste of taxpayer dollars. For what? And then on the part of Belco, they're to blame also. They did a good job, but perhaps not to the extent now that DIR is mandating. I mean, this is crazy. And perhaps, and I suspect the people for the city of Los Angeles are pissed off. Okay, I think I'm leading to where this is heading, but you can see that when you're doing public works, you're going to have to pay your workers anytime you have control of your worker. If they show up at an office and they start loading things into either a company truck or their own truck, well, prevailing wages start. And when they finish the day, however it's defined, whether they leave the job in their own vehicle or in a company vehicle, the clock stops, unless it's an emergency. If you don't know these rules, just go to my site, laborcompliancegroup.com. Here are a couple courses I provide. This California DI Labor Compliance Rules and Regulations. I explain everything that all these complaints are alleged against Belco. So for $277, for goodness sakes, you're going to get all the answers. And then if you think you know what you're doing, and it's a California prevailing wage project, well, here's just the frequently asked questions, and it's $41. Make the simple investment. It will save you so much in the way of dealing with issues like this. LaborComplianceGroup.com. Then, as we move forward here, and I don't know why they made such a big deal of this, but in this, they said there's two different yards. Big deal. Okay, they're about a quarter of a mile from each other, and they're about a quarter of a mile from the project. Again, big deal. Whether an individual shows up at yard A or yard B, the clock starts ticking. It doesn't matter if it's Belco or any other company. You need to know when you start paying your workers. Then it goes in and they just go over this again and again and again about safety requirements. Well, that's just standard operating procedure and has nothing to do with prevailing wages. All right, other than the fact that there's a third party that, for safety purposes, made sure during operational hours that the workers were keenly aware of oncoming trains, and that clearly you want to void any actions with a train. The Soley Miller yards referred to two locations. Okay, again, big deal. Meanwhile, okay, we're still going on, and the argument over and over and over again is, when did people start? When did they stop? If there was overtime or not. Meanwhile, some OCC witnesses testified that they attended Rail Pro safety meetings. This is the third-party group that provided daily safety meetings, and it was a requirement. Well, when you start asking the workers, they go, well, I don't remember. Well, maybe I attended. Well, maybe I did. Oh, I don't remember what time. Oh, it was at 6:30 in the morning. Oh, it was at 7:30 in the morning. It was at 9 o'clock in the morning. Again, there's no consistency here. This guy said he attended 6:30 a.m. daily safety meetings. Another guy said 7:30. Another guy said 8:15. According to Caldera, some workers arrived before 6:30, but they did not start work until the 6:30 a.m. safety meeting with Rail Pros. You know, they were sitting in their cars drinking coffee. Again, it's just commentary. Ibarra did not recall attending any safety meetings. You could see how hard it is to piece this together. You are the general contractor. Guess what you need to do? You have to babysit your workers. I hate to say it, but this is what you're going to face. You're going to get this he said, she said. So your foreman had better start tracking everything on a daily basis. So the next argument is, did the workers, and they're going to go in and say, well, I loaded the truck. And well, that's just standard stuff. That's not a big deal. The other argument here is, what time did they end their day? The post-project site activities. This means, did the workers finish their daily work and then have to drive back to the shop, which is 5 minutes away, and unload vehicles? Well, again, this is one of those deals, he said, she said. Well, yeah, we did. No, we didn't. No, I drove home as soon as the day ended. I drove home in a company vehicle as soon as the day ended. Sometimes the day ended at 2:30. Sometimes the day ended at 3. Some would say, oh, I worked till 5. And then some said, I worked until 2:15. Okay, you could see this roller coaster ride of opinions, or lies, or any way you want to interpret it. As the foreperson, Caldera was the last to leave because he was responsible for making sure that everything was picked up and secured. Caldera did not want to miss his son's baseball game at 3:15, so they usually left the job site by 2:45 p.m. Okay, that's the last guy leaving. But now the weight is on Caldera. Does he have any credibility? This guy testified that he stopped work at 3 or 3:30. You can see where we're going here. If you're not tracking this stuff, you as the employer, you're going to face this problem. Again, you're going to get these guys that said, yeah, I worked till 3:30. Then I worked at 4:30, 3 out of 5 days. And this guy, oh no, I left at 4:30. And then some of these guys said, I left at 3:30. Well, the start time, well, 6:30, or was it 7? The contractor's rolled report. You can see whoever had to audit all this stuff is just, they're pulling their hair out, just going, holy cormoly. Because if you fail, keep track of this stuff. You have 32 workers on your project, Belco. You failed terribly here, horribly, because your foremen were not doing their job. So my recommendation is you automate all this stuff. And I think there are apps out there that'll do this very easily, where your foremen, yes, they're going to be interrupted, but that's just part of the job. They're going to have to track all this stuff. Then your workers, and I don't know why this is not noted here, but your workers need to sign in and they need to sign out. On a public works project, there's just no argument. Those are the procedures. Sign in, sign out. We're going to go back and forth, back and forth, back and forth. Then it comes down to, he said, she said, on and on. You can see on and on and on, and I'm not going to bore you to death here. Then this guy, DeLeon, goes on and he just argues, I've got all these facts, so on and so forth, about being on the project. Well, DIR said, Mr. DeLeon, no. Your records they're worthless. And basically, that's what they say. They're moot for the most part. So again, even though someone states that they have audited information, is it credible? The next argument here, and we're going on about DeLeon and whether what he said and what he did are accurate. There was conflicting testimony, again, back and forth. The foreman said one thing, the worker said something different. Someone has to weed through all this and make that final decision. DeLeon's cell records do not support his testimony that he typically arrived in San Fernando between 5:45 and 6 a.m. All right, so the guy lied. Wow, there's nothing new about that. And you could see to the point where, in terms of auditing this stuff, this is the details that DIR is going to go through on a $900,000 penalty. Or in this case, perhaps Belco's attorneys did this. If I was Belco, yeah, I would demand all the records and the accuracy being defined. And then you're going to read on and on and on about what the foreman said versus what the worker said. And you can go through this piece by piece. But to avoid all this, what are you going to put in place? You're going to have a sign-in sheet. You're going to have a sign-out sheet. I mean, just old-fashioned, sign your name, sign out. All right? That means literally on the job. And if need be, if the foreman is trying to manage his people and they said, well, I signed out at the shop while the foreman's still on the job who has a sign out sheet, you can see the problem there. So this is an operational challenge that small and large companies need to tackle. The alleged unpaid overtime hours. Belco's witnesses denied any unpaid overtime hours on the project. Ochoa denied that he or the workers on the project worked overtime on the project when he was the foreperson. All right, Mr. Ochoa, fine. Then the rest of the people said, no, all right, maybe there were some unpaid wages on the project, but they were insignificant. Well, all right, that's more reasonable, but this Ochoa guy saying flat out, Then we're going to get this OCC's witnesses consistently testified that they were not paid overtime on the project. All right, again, you got 47 pages of 35 saying he said, she said. And in the end, we're going to find out who was right and who was wrong. The alleged unpaid rest and meal breaks. Again, you could see the consistency here. You, as the company, I mean, this is just ridiculous. When your workers go to this length to bitch and moan, you don't want them working for you. But sometimes you don't have a choice. These 9 people were a real pain in the ass. But on the other hand, your foremen were not the sharpest knives in the drawer. If Ochoa was doing his job, and if Panera and everyone else were doing their job, if the certified payrolls were correct, we wouldn't be having this argument here. So there's just so many errors in this entire process that hopefully everyone learned something here. That there were unhappy workers, there were unhappy foremen, there were unhappy OCC people, there were unhappy DIR people. You can see that this was a bloody nightmare. So in this case, there's this stacking thing. Okay, some of the foremen said, look, our guys don't like taking this 10-minute rest break. We're just going to add it to their meal break. Others said, well, we never got our full breaks. And this is not uncommon. You hear this all the time. So what's the bottom line here? For goodness sakes. I mean, this is ridiculous. But this is the extent you have to go through with these policies. I mean, and look, I hear it all the time. You're going, Williams, you expect us to track this stuff? I call it, I don't, but DIR does. Seriously, I mean, this is what you're going to have to go through. So now it took all this information and now it's the decision. This discussion here, this is just standard language that DIR implements in the first opening as to discussion here. I'm not going to repeat this, but I'm going to go in and here, there's an introduction of some new information here that it's new to me. It says when a labor compliance program, and I said there's only 4 in California, such as OCC, determines under section 1771.5 that a violation of the prevailing wage law has occurred, it may issue a notice of the withholding of contract payments pursuant to section 1771.6. Well, this is not unusual because general contractors can do the same thing to subs if they find that there's a possible violation. So that's nothing new. An affected contractor or subcontractor may appeal the notice by filing a request for review under section 1742. That's nothing new. OCC has the initial burden of presenting evidence that provides prima facie support for the notice. Legal stuff. When that burden is met, Belco has the burden of proving that the basis for the notice is incorrect. Normal standard proceedings. At the conclusion of the hearing, the director issues a written decision affirming, modifying, or dismissing the notice. And here's what the director said. OCC presented prima facie evidence that some workers performed overtime for which they were not compensated properly, but not nearly what was assessed. The single prevailing rate of pay for a given craft, classification, or type of work is determined by the Department of Industrial Relations in accordance with the standards in Section 1773. Contractors and subcontractors are deemed to have constructive notice of the applicable prevailing wage rates. This is just notice because this information is available online. Ultimately, the DIR's wage determinations determine the proper pay classification for a type of work. The nature of the work actually performed, not the title or classification of the work, is determinative of the rate that must be paid. And I preach this over and over again. And I get the argument is, well, how do I know? The decision about which craft or classification is appropriate for the type of work requires comparisons of the scope of work contained in the wage determination with the actual work duties performed. And to this day, I get calls almost daily, and I always instruct them, stop making assumptions, read the scope of work. And they still look at me going, what are you talking about? And I say, the scope of work that we discussed over and over again. If you don't know what the scope of work is, you know that $277 simple investment? I spend a lot of time and a lot of emphasis explaining the scope of work. If you don't know it, then stop doing prevailing wage projects. Every employer in the on-site construction industry, this is something that you should be aware of. Every employer, whether the project is a public work or not, must keep accurate information with respect to each employee. Here is the requirement: Industrial Welfare Commission Wage Order number 16201, which applies to on-site occupations in the construction industry, provides as follows. This is what you need to keep in terms of information. Also, the employer must furnish each employee with an itemized statement in accordance to this particular code. Employers on public works have the additional requirements to keep accurate certified payroll records. These records must reflect, among other information, the name, address, social security number, work classification, straight time and overtime's work, etc., etc. You have to keep this information, and if DIR wants it, you got to provide it to them. In this case, it was OCC. You don't do that, guess what happens? You're going to pay a huge legal fee to have an attorney represent you and then weed through all this stuff. When the employer fails to maintain accurate payroll records, the employee may demonstrate his hours by producing sufficient evidence to show the amount and extent of that work as a matter of just and reasonable inference. That's why DIR OCC pays favor to the worker. If you, as the employer, fail to keep accurate records, you're already in violation. But two, that's just poor workmanship on your part. You shouldn't be in business if you're not keeping records. Bottom line is, you're doing public works projects, the burden rests on you as soon as you sign that contract. Then we go back to OCC and the hard work they did. All right, I know I pick on Jensen, but you get the point here. OCC went the extra mile to try to protect the worker. If the employer, and so many of you employers out there fail to do this, I'm just going to warn you. You either like to gamble, or you're just doing, maybe this is a one-up public works project, but look, you don't follow the rules and regulations. Yeah, that snake's going to bite you in the butt, and when it does, it could be ugly. And right now, you're looking at a $900,000 penalty. $900,000. And this project is not that big of a deal. You're putting up signal lights. It's probably a $2 million project, and now you've got nearly $1 million. Nearly half of it's a penalty? Are you kidding me? We go back to this OCC, and they assess 3 hours of overtime for each worker based on the assumption. Here we go again. You're going on that assumption. You can't make assumptions when you're doing this. No, you cannot make assumptions, period. You have to babysit these projects. I hate to say it. That's why they're so expensive. OCC being a big error. And then they just came up with this wild ass number. Additionally, based on the evidence available to OCC at the time it completed the notice, it was not reasonably to assess 3 hours of overtime for each worker identified in the audit for each hour worked. This is DIR saying, OCC, you overreach. You can't just make stuff up. And then they go into the travel time. Are workers entitled to travel time, et cetera, et cetera? Well, I've beaten this up time and time again. And this is saying that, well, Marillion versus Royal Packing, yeah, the worker's entitled to travel time. But here we go again, and I was not aware of this. I have two very, very, very harsh videos because DIR overrode everything that was recognized in terms of travel time. And this is fairly recent. There were two arguments that Caltrans made that DIR said, no. But DIR didn't mention this particular case. And here it says, more recently in Hereta versus CSI Electrical Contractors, 2024, the Supreme Court noted that Marillion did not assess whether the employer's time was compensable as employer-mandated travel. That's critical. That's critical here. Because when Caltrans stepped up to the plate there wasn't any mention of this employer mandated travel, which turns on whether the employer mandates travel to a second location after the first location where the employee's presence is required. This is again about who's controlling who, and if you have control of the worker, in other words, you say you have to be here or you have to do this. From the employer standpoint, well, that particular worker is entitled to prevailing wages, even driving. But then if you state something to this, and this is just quote from DIR, if you say, well, you just need to show up at the job on this date at this time, that's the only requirement. How you get there is not our responsibility. Then you don't have to pay any type of prevailing wage. And it really has nothing to do with how far that person drives. When it is required for employer-related, you can read this to the T, and you may consult an attorney who could fine-tune this, because if I make any comments, I'm making an opinion, and I'm not going to make it an opinion. It's just reread or review some of the information that I brought to light on the two other arguments in, I forget the two cases. Go to YouTube and you can listen to those two cases. But here, this is where DIR saying, no, employer doesn't have to pay if the worker had the right to go home at their own leisure. They could either drop the vehicle off, they could drive their own car. In the end, OCC had no right to charge the employer for travel time. Then we're going to go into unpaid overtime hours, so on and so forth. And then it really comes down to, accordingly, it was unreasonable for OCC to assess 3 hours of overtime for each worker based on the assumption that each worker was required to report to Chino Yard before and after their workday on this project. Again, OCC made some egregious errors. The evidence presented at the hearing, as summarized in the decision, showed that even between the 9 workers that testified, there was significant variation as to each worker's experience regarding when and where they reported for and left work as to the work they performed, if any, off the clock. This further evidenced unreasonableness of OCC's methodology of assessing 3 hours of unpaid overtime for each day a worker worked 8 hours. To bolster OCC's justification for assessing 3 hours of unpaid for each electrician and laborer on the project, Jensen reviewed De Leon's cell phone records and determined that averaged over the 34 days he worked on the project, De Leon was not paid for 2.91 hours per day. Okay? So De Leon's records were somewhat helpful, but again, a sample size of 1 is not very accurate. Belco paid its workers the applicable union rates, which was higher than the required prevailing wage rates in the applicable wage determination. Now, here is what is common, and this could take a little bit of time. Okay, to calculate the unpaid overtime premium amounts owed for each worker, OCC utilized the actual basic hourly rate Belco paid its workers rather than the applicable public wage determination. OCC's reliance on the higher wage rates that Belco paid its workers was misplaced, although OCC is correct that Section 510 requires hours worked in excess of 8 hours in a workday be paid at 1.5 times a worker's regular rate of pay. The enforcement of Section 510 is outside the scope of OCC's authority in issuing a notice of withholding of contract payments under Section 17716. Ouch! Who picked that up? That is just microscopic. A really good attorney found that's what you have to face when you're dealing with this stuff. Pursuant to Section 17716, Subdivision A, OCC may enforce the provisions of this chapter, referring to CPWL at sections 1720 through 1861, found in Part 7 of Division 2 of the Labor Code. See Code Regs, Title 8, Section 434, a labor compliance program shall have a duty to the director to enforce the requirements of Chapters 1 of Part 7 of Division 2 of the Labor Code, and these regulations in manners consistent with the practice of the Labor Commission. Section 510 is found in Part 2, Division 2 of the Labor Code. Therefore, a violation of Section 510 is outside the purview of notice issued under Section 17716. Wow. Didn't think you would know that, huh? That is microscopic. These flaws in OC's methodology rendered the audit woefully deficient. OCC did not draw a reasonable inference about the amount of unpaid overtime hours allegedly worked by the workers on the project. In addition, OCC did not utilize the required prevailing wage overtime premium rate set forth in the applicable wage determinations to calculate the amount of unpaid overtime on this project. For this reason, OCC generally failed to carry its burden of proving that the evidence providing prima facie support for the extent of the underpayment of overtime assessed, while still offering evidence that some workers performed work for which they were not compensated properly, as later acknowledged by Belco. Wow. Ouch. That is a huge oversight. That's why there's only 4 legacy labor compliance programs out there. They missed it. They missed it by a mile. All right. So now Belco acknowledged some unpaid overtime. Well, as I said, everyone lies. Although OCC did not prove the entirety of its notice, Belco acknowledged in its post-hearing briefs that if the testimony of some of the workers was to be believed, those testifying appeared to be owed unpaid overtime for certain days on the project. Okay, so here it is. You have this huge, massive undertaking on the part of DIR. You have a $900,000 assumed penalty. Well, DIR is never going to let you off scot-free. They're going to say, okay, Belco, we hear where you're coming from, but you've taken up a lot of our time. You've taken up a lot of everyone's time because you just failed to follow all the rules and records. So with that being said, if you fess up, and I'm shooting from the hip here, but there's always give and take. So Belco just said, look, and I'll settle up for this thing. We'll pay whatever overtime is presumed. We probably won't say it, but again, this is the way it works. So Belco's probably gonna have to pay up something here. Now, here is what happened. When you calculate overtime, generally calculated wrong. If you make a simple investment of whatever it is, less than $300, I'm going to show you how to calculate the proper overtime. Here, DIR goes through and they're going to mince this up and they're going to go this rate and that rate and this and this. And OCC did this and they did it. Well, they did it wrong. This is supposed to be an entity that knows what they're doing. Jenkins guy, 10 years, I would think he'd know how to calculate overtime. But he did it wrong. And then DIR goes in and says, well, okay, here's what they did, but this is the right way to do it. I'm not going to go through this. You can go here in an 8-step process. Pretty basic, pretty simple math. But again, there's always deficiencies when it comes to anything DIR proposes. And in this case, everyone screwed up. Everyone screwed up. And the bottom line here is be cautious here, because in the end, you're going to see that these individuals, this DeLeon, after all of this work, he got $5,000 in overtime. This Ramblaz guys, he got $1,500. This Baldera, $220, $708. All right, I mean peanuts. For what? $100,000 in wasted time on the part of OCC. Probably $100,000 in DIR's time to do this. And I have no idea what Belco would have had to pay their attorneys. But look, this is foolish. This is just foolish. Then, as a result of missing overtime, there would have been an unpaid training fund contributions. It's just hat and hat. So there were 192 hours of unpaid overtime, which is peanuts. Which is what, $300? Again, ridiculous. Then there's going to be the penalties. Failure to pay overtime, there's a penalty. And then this Jenkins guy's just went wing dingle here. He just said arbitrarily, because the contractor or sub failed to pay the proper prevailing wages, there's a $200 day penalty. And DIR has discretion over that, and they're saying no. Belco has never run into problems with prevailing wages. This Jenkins guy had something out for subs, and I don't know why, but the guy went on and saying, well, these contractors just don't pay overtime wages, and they've been doing it since 1965. Anecdotal. Then he comes up with this number, $200. Well, DIR's going, well, Belco has never screwed up in the past, so they lower it to $40 a day. The point here is, you working as a subcontractor or a contractor doing prevailing wages are subject to this problem. The city of Los Angeles, they do a lot of public works projects. Guess who you're dealing with, all right? Now you know who it is. It's this Jenkins guy. I don't know if he's still there. This was issued just 3 weeks ago. Or a month ago. So, Mr. Jenkins, if you're still there, perhaps you have rewritten your policies, because it's shameful what you've done. You've wasted taxpayer money. Belco, I hope you've rewritten your policies. And maybe after you guys watching this, maybe you'll take this into consideration of what extent OCC went in order to crucify you. So in the end, there was little in terms of violations on the part of Belco. They were doing the best they could. They had a bunch of workers that lied, all right? And then there were a few Belco workers that weren't truthful, and that's not uncommon. There was a lack on the part of Belco in terms of their record keeping, shameful. There was a huge part in terms of their regulatory capability. And then DIR had to spend an enormous amount of time to siphon through all of this. So in the end, here's the outcome. The work subject to the notice of withholdings of contract payments was performed on a public works required the employment of apprentices. City of Los Angeles Office of Contract Compliance served the notice. Belco Electric filed a request for review timely. No back wages have been paid and no deposit made with the Department of Industrial Relations as a result of the notice of withholding of contract payments. This is just the normal stuff. This is the final ruling. City of Los Angeles Office of Contract Compliance did not meet its burden to provide prima facie support for the notice of the withholding of contract compliance in its entirety because it did not draw a reasonable inference with regard to its calculation of the alleged hours of unpaid overtime, and because it failed to utilize the proper prevailing wage rates for each applicable classification based on the bid advertisement date for the project. Belco underpaid the following workers for a total of, what is that, $9,000, $8,000? Belco liable for unpaid training fund contributions, a couple $100. This is what really sucks. They have penalties, and then they have liquidated damages. If you don't know what liquidated damages, well, again, for a $300 investment, take a look at my course. In the end, a $900,000 penalty shot down to wages due, $9,800. Training fund contributions, $217. Penalties under $1,775, $6,500. Penalties under $4,100. Liquidated damages, $9,800. 6560 is probably this overtime deal, and the 4100 was probably overtime and a few other things. So 30 grand. That's it. I know you're not going to get away for scot-free, but imagine you're the CEO of Belco and you have this $900,000 penalty. You think the guy had a few sleepless nights? Bottom line here, kids, it's all about record keeping. Record keeping. Dot the I's, cross the T's. Brad Williams, Labor Compliance Group. Thanks for watching. See you soon.